All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Supreme Court. Please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is State of Florida versus Zachary Wester, number 2024-1769. Whenever you're ready.
Good morning, Mr. Chief Justice, and may it please the court. Jason Muehlhoff on behalf of the state of Florida. The Florida legislature intentionally crafted the Florida RICO Act to be broad and to cover a wide array of criminal activities. As relevant here, it also made it illegal for any person employed by any enterprise to participate in such enterprise through a pattern of racketeering activity. That includes Zachary Wester's conduct here. All parties agree that he is a person who was employed by the Jackson County Sheriff's Office and that he used his position to commit a pattern of racketeering. Specifically, he pulled over unsuspecting victims, planted drugs in their cars, and then arrested and helped facilitate the prosecution of those improper drug crimes. Nothing more is needed to uphold his RICO conviction. And yet, the first DCA demanded an additional element, specifically that the state prove Wester coordinated with 2 or more people to facilitate some illegal objective. That requirement is not found in RICO's text, nor is it supported by this court's precedent or federal precedent.
Counsel, could you distinguish the requirements for a conspiracy charge from the elements as you see it for an individual person's racketeering under the RICO statute in connection with a criminal enterprise?
Certainly, Your Honor. So conspiracy is generally understood to be the agreement between 2 or more to facilitate some illegal objective. Here, you need some person who is employed by any enterprise or participate in any enterprise, and to be able to use that relationship to the enterprise to facilitate the pattern of racketeering.
So the state's position is that the substantive RICO charge does not require more than one person, but a conspiracy charge obviously would, because it would require an agreement.
Exactly, Your Honor. And of course, there's going to be plenty of times where I believe it would overlap, and subsection 4 specifically envisions the idea of a conspiracy within the pattern of racketeering, but there is universes where it can be separated.
Do you think the First District was incorrect in their reliance on our precedent to support their position? Because they leaned pretty heavily into that.
I do, Your Honor. Specifically, Gross, this Supreme Court's opinion, it's interesting what they did there. First, for context, Gross decided a circuit split on the scope of enterprise and decided it in favor of the broader definition. And in doing so, I think it's safe to say they rejected the idea that it has to be connected to organized crime. They described the circuit split really as a theory of legislative intent and whether you think it has to address the mob or something like that, as opposed to a broader connection. But there, I think they really latch on to the idea that you have to have some common purpose. And here it's clear that the sheriff's office has a common person. It is to do law enforcement. And so it's a little bit unclear how they think a broad definition of gross actually undermines the claim here, when everyone agrees that the statute clearly envisions a government entity being a qualifying enterprise.
What about doorball?
Doorball, similar, Your Honor. I think doorball really just stands for the basic idea that you cannot associate with yourself as the enterprise. And that makes sense. If that was true, there would never be a time where a crime couldn't qualify as an enterprise, because you always associate with yourself whenever you commit any crime. And so I think it was really just establishing that you can't go that far. But of course, what you have here is Zachary Wester and the sheriff's department being the qualifying enterprise.
Counsel,
Go ahead.
your brief or your approach to the text in some ways resembles Justice Gorsuch's approach in Bostock, just looking at the text and ignoring sort of the context when the statute was enacted. Can you start by focusing in particular on enterprise and what was going on in 1977, Can you explain, is your position more like Justice Gorsuch in Bostock or Justice Alito in dissent?
Well, it's certainly not Justice Gorsuch, Your Honor. I think what we have is more along the lines of what Justice Kavanaugh and Justice Alito had in their dissent, which is understanding the provisions as naturally read. And here what we have, and specifically through connecting the conduct in the enterprise to the pattern of racketeering activity, it is clear that what Wester did here was only made possible through his employment at the sheriff's office. He used the patrol car to pull people over. They got out of their car because he had the badge. And so we actually think that it's just naturally connecting all the terms, which I think is safe to say how Justice Alito and Kavanaugh approached it.
So you think the sheriff's office is like the mob? I mean, focusing on enterprise can have a variety of meanings, and you focused on like a positivist approach to the definition of enterprise. But there's another meaning of enterprise, just taking the context of when it was enacted, that has to do with an undertaking, some sort of, an undertaking to violate the law in some sort of organized way. And in that context, the definition could say, these are the different ways that you can engage in an enterprise to violate the law. Mm-hmm. But so you're reading it as if that is actually the definition, to the exclusion of what enterprise probably meant at the time it was enacted.
So, Your Honor, 2 points there. I certainly agree that if you were just to ask what is an enterprise in a vacuum, it might have a different understanding. But here the legislature defined what an enterprise is. And so we were applying the standard principle of textual interpretation, which is when the legislature defines a term, you use that definition here.
So when is it fair to take into account the context in which that definition was adopted, or the entire, provision was adopted?
So I think context is inevitable to doing proper interpretation. You have to understand what the words mean, and the way you do that is by looking at the words within the clause compared to the entire statute. But I would also push back, Your Honor, on the assumption that the purpose or the context behind the statute was only to target organized crime. I think the U.S. Supreme Court makes that abundantly clear in the H.J. Inc. Case, where they specifically say, although that might have been the animating purpose behind why Congress started the process of creating a RICO charge, the words that they actually use and the words that they actually ratified go far broader, and those are the words that control here. And I think the same is true with the Florida RICO Act as well.
So I understand all of your arguments against reading the two minds thing into this, but it seems like your position is basically to kind of, I don't want to say rewrite, because I think that would be unfair, but you're basically kind of, restating what it means to participate in the enterprise through racketeering activity, and you're basically saying that if you use the enterprise to commit your racketeering activity, and I'm not sure. That seems like if I were writing from scratch, that seems like it would be a reasonable thing to do, and it seems like a much clearer way if they had just said to conduct the enterprise through a pattern, or to use the enterprise to commit. But it seems like you're not necessarily explaining why it was written the way it is. And I'm just I don't know that it necessarily gets to what they're saying, but could you help us understand just kind of why it would be? Because it is a very awkward, if the point is, hey, if you're part of an enterprise and then you use your authority as a member of the enterprise to then commit crimes, this particular wording is kind of an awkward way to get to that concept.
So certainly agree, Your Honor. We were trying to find some shorthand way of saying these qualifications, but there's so many dependent clauses, it's hard to, I think, put it in a more streamlined way. But what we tried to do was stick to the text and all the clauses. And so what we think the fairest reading is, and if I understand your question correctly, it's connecting the involvement with the enterprise to the actual racketeering.
And also not just the involvement, but participating in the enterprise. I think that sort of the intuitive appeal, it may not be a textual appeal necessarily, but kind of the intuitive appeal of what they're saying is that when you talk about participating in an enterprise, it kind of implies that there's some sort of joint activity distinguished here from the conducting the enterprise, which is sort of, directing it or leading it or whatever. And so it does seem like, just from a matter of language, it does seem like a strange way. If I'm just this kind of rogue person that's out there abusing my authority and whatever, that to describe, if I said to you, if I explained what this policeman was doing, I don't think any reasonable person would describe it as, oh, he's just participating in the enterprise of being a policeman by planting evidence on people. I mean, that's just a very unusual way to describe what it is that in the facts here, what was going on.
So I would say 2 points in response, Mr. Chief Justice. The first is looking at the text. I do think that they purposely, and even if it is a little bit awkward in its wording, envisioned a very broad standard here. And so it is any person to conduct or participate directly or indirectly. And so to use that same hypothetical, if you were to ask the person on the street, I think they would say the police officer who's going rogue is at least indirectly participating or at least indirectly conducting. And the legislature there used this kind of broad catch-all category. And then, but taking your question head on, I would also point you to the First Circuit case in Ruiz and the Seventh Circuit case in Shema. Both of those kind of address the same question, I think, which how is an officer who is abusing his authority connected to the underlying enterprise? And in both cases, I think they make clear that what's happening is he's using the enterprise and distorting it, but in a way that still qualifies within.
Is your case any stronger if there is another criminal mind in the police department or at the state attorney's office, or is your argument sort of independent of that fact, like in Shema and in the Ruiz case, the First Circuit case? Is there any allegation in either that the police officer who was doing more or less what was happening here acting alone?
No, Your Honor. There were multiple actors in both of those cases, though when you read the analysis, I don't know that it turns greatly on the fact that there were multiple bad actors. But I do think, to answer your first question, the only reason it would be easier if there was another bad actor here is because the first DCA added that requirement. We don't think under the text that it becomes any easier or harder, but it does address what we think is an improper standard. So in that sense, certainly.
So you don't think that I understand that your argument obviously is that we can't just kind of ask what would a reasonable person think an enterprise means. We've got to look at the definition here, and it says that it can include licit as well as illicit and governmental, but it seems like, you could read that as saying that the enterprise itself has to have somehow been kind of corrupted. If you're starting with illicit governmental enterprise, that in order to fit within this, that the enterprise would have to have been itself kind of corrupted, and then you or the actual individual defendant participates in that. I mean, the enterprise really isn't. The enterprise here is just he's a member of it, but then as far as participating in it, it's really just his own individual acts that we're talking about.
Yes, Your Honor. I would say it's more than just it just so happens that he was employed. I mean, he used the resources and the authority to.
No, I agree with that, but he still is. I mean, it's almost like he's not really participating in the enterprise at that point. It's like he's kind of off. He may be relying on his authority as a member of it, but he's no longer like participating in the enterprise. I do think it implies kind of a joint endeavor of some kind, and it could be that a previously licit thing has been kind of tainted, which I do think that that's part of the broader context of the RICO thing, is kind of taking over legitimate things and turning them into illicit operations.
So 2 points there, Mr. Chief Justice. The first, I think Chief Judge Osterhaus has a good point on this, and it's specifically that people in the sheriff's office clearly did work with Wester, as did the prosecutors, the state attorneys. Now, they didn't do it knowingly, but as the Chief Judge points out, there's no knowing or mens rea requirement within the RICO statute. So I still think kind of the concerns that you have were met here. Multiple people, whether it be the person who puts them in jail or when the prosecution comes, those are all involved in coordinating with Wester. Again, not knowing that they had done it, but
so you think so? Would it? I mean, if we were, do you think that should be, if we were to rule in your favor, should that be sort of a limiting thing? I mean, is that something that was, is that like an element of this that it just maybe so happens, but it, should we say that that's kind of critical to this being upheld, the conviction being upheld?
There's multiple people? Sorry,
yeah.
I'm not sure what the
question was. So she's saying there has to be an actual sort of joint understanding that you're going to do something criminal. You're saying that, well, there were other people involved, even if they didn't know about it. The other extreme would be like he just, nobody knew and whatever, but he still was using the authority of his office to do it. Are you saying that that middle category where there's where he's relying on other people in the enterprise to be able to accomplish what he's doing? I mean, is that a necessary part of him being found guilty of this?
I think you could imagine examples where it's just using the resources of the entity. Now, as applied here, yes, other people were involved. But for example, by placing drugs in the person's car, that is a predicate offense. And yet at that point, nobody else had been involved. So I think it would depend slightly on the facts. But to your original point, Mr. Chief Justice, about the licit or government entity having to have some kind of corruption within it, I do think that confuses, or at least doesn't give full weight to the enterprise definition. Because as I understand the first DCA and Wester's position, you have to have two illegal actors, but that is itself a separate enterprise definition. It is two people or a group of individuals who are associated in fact, but not a legal entity. And so in any crime, you would just say, well, no, that was the enterprise. It was the two bad actors. And yet the legislature here gave a list of valid, whether it be a corporation, a union, or a government organization. I just don't see how under this theory you would ever have those entities be the qualifying enterprise, and yet the legislature clearly envisioned that could be the case.
Well, that's why I asked, going back to my Bostock question, it seems like you're approaching this with blinders on. You're just looking at the words themselves in a definition and ignoring the context of the entire statute and what this statute is. I mean, RICO is a very particular type of crime, and it was well known at the time in the 1970s as what was going on and what the federal government first and then the Florida government was trying to do to get at it. And you're now focusing on, oh, well, we have this definition about enterprise, and look, we can go after one individual, unrelated, he's not involved with anyone else that's trying to embark on some sort of criminal endeavor. It's just him using his employer to commit crimes. And so you seem to have expanded the reach of this crime beyond what was originally envisioned when it was enacted. And with that is, so could it be an alternative, like looking at the call the definition of enterprise as we're identifying all the different ways that an ongoing criminal endeavor could be, be the, not the predicate, but the base for this crime, which it seems that is the point of the crime, is that you're engaging this organized activity in some way. It may not be legally incorporated, but these are people associated to commit some criminal activity.
So 2 points, Your Honor.
And that's, was it Turcotte and Gross and Doorbal, they all seem to anticipate that as part of it.
So 2 points, Your Honor. One, this court has said time and time again that broad purposes, a statement must yield to the clear text. So we do think it's sufficient there. But I do want to take your assumption head on.
Well, that's what Gorsuch said, too.
Well, Your Honor, I think Justice Gorsuch was wildly incorrect, but that was because of the specific text of the statute. But on your point about what is the RICO Act for, I think it's 2 points. No one doubts that it included organized crime, the mob, the mafia, what have you. But the other thing, and this is in the third whereas clause in the preamble, is also the corruption and infiltration of legitimate entities. And that's exactly what we have here. Zachary Wester abused and corrupted a legitimate entity that is given great authority under the state. And so what makes his crime unique, it's not that he coordinated with other people in the way that a mob normally does. It's that he had resources that if he was just a lone wolf on his own without any institution or any entity, he couldn't commit the same level of damage, the same level of harm to these individuals. And that's why RICO has these supercharged abilities for the government. It's the ability to do more crime and to do more damage because you have an enterprise backing you. It's not just that there's multiple people in some organized scheme.
Am I correct that the only sort of purpose-driven argument comes from the Act's preamble? It's not from any statutory text. Is that correct?
Your Honor, again, we think it's a clear reading of the relevant provision. You could read in purpose from any number of sources, whether it be general.
But the first DCA used the Act's preamble. I
think it's the preamble, and I also do think it's a preconceived notion about what RICO is for. When you do most statutory interpretation, Chapter 604, you have no idea what it is, and you're informed as you read the text. I think RICO is one of the few statutes where you have a general or vague notion of what it's supposed to do, and I think that probably bled into the analysis. Happy to answer any other questions this court may have, but otherwise I will cede my time until rebuttal. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Barbara Basharis, representing Zachary Wester. We're asking the Court to affirm the First District Court of Appeal in their reasoning on the scope of what it means to participate in an enterprise through a pattern of racketeering activity. We actually agree with much of what you just heard in the state's argument. RICO was enacted to combat organized crime in the traditional sense and was intentionally drafted much more broadly so that it could reach more than simply, the Godfather style mob activity. Both of those things are true. RICO also applies to any person. You can be a single actor and commit a predicate act, and if you're part of a RICO enterprise, you can be held liable under RICO. But it doesn't logically follow that merely because you are employed by a government entity or a company that any predicate act you commit is going to give rise to a RICO violation.
Is that really the state's argument? I mean, it seems to me that they have a colorable argument that it isn't just the simple act of employment, it's the deployment of the instrumentalities of the office in a way that facilitates the predicate act. I mean, one way I think you could hive this off from some of the hypotheticals that you brief about how any employee can commit a RICO violation is that in this case, Mr. Wester was clearly relying on the indicia of his authority to sort of do what he was doing in terms of planting the drugs, and also was sort of using the instrumentalities of the office to advance the prosecution of his targets. It seems to me like that's different from, saying that any postal worker who steals mail from someone's post office box is using the United States Postal Service as his enterprise in a RICO charge. I mean, am I wrong? Tell me, respond to that sort of argument.
I think the problem there is that in both examples, Justice Curiel, the only reason the person had access to the instrumentalities of the offense is through their employment. And we do have, and it was charged in this case, an offense of misusing public office. But every misuse of public office is not necessarily a RICO violation. What we lack here, and what the first DCA correctly pointed out, is any acting in concert, whether with another entity or another individual, because that really is the core of what RICO gets at over and above other criminal statutes. RICO criminalizes acting in concert to acquire interests in business and acquire control of business, or to operate a business. Those are the three main subsections of the statute, whether it's the federal or state version.
Now, what is your response to the state's argument that in acting with concert, the statute doesn't have any sort of mens rea requirement for those that the person that's being charged is acting in concert with? So in other words, like Chief Judge Osterhaus frames it as a nexus. So this isn't mere, abuse of a public position, that the person being charged is truly acting in concert with this enterprise. There's a nexus between the power and the authority that's being leveraged in this particular context, in the context of racketeering activity. So,
Your Honor, I think that reading doesn't give enough weight to the meaning of participating in the enterprise through the pattern of racketeering. There's a common sense meaning of participate, and that's what a lot of this comes back to, is what does it mean to participate? And the cases are sometimes not helpful, because in all of these different cases, people are participating in different enterprises. It's fairly unusual to have a purely licit enterprise that is alleged to have absolutely no connection to the acts other than the proximity of employment. And so the problem with that is that it takes any tool of employment, really, anytime somebody uses a tool of employment, and would allow a crime committed to rise to a RICO violation without that sense of participating with or in activities.
So can you explain this scenario, because you started out by agreeing with the state that this could be a single actor, that the statute allows for kind of the single actor scenario. So can you describe a scenario where it would be a single actor participating in an enterprise that would fall within the statute's reach?
I think the most obvious example is, and I'm drawing a blank on the case name, but if you have an individual who is also the sole operator of an incorporated entity who uses that entity to accomplish illegal acts, then
so how is that any different from a factual standpoint? It's the Wester in this case is leveraging the enterprise, and this falls within the legislative definition of enterprise, even if that's not something somebody would expect, on his own, but certainly leveraging all aspects of this enterprise for the purpose of the criminal activity. So I just don't see how that's any different from the scenario you gave.
I think it's different in two ways. One is the element of control, and the cases have been fairly consistent. I realize the Florida statute and some state statutes are drafted broadly enough that some courts have said you don't have to be the director or the chief operator of an enterprise, but it doesn't follow from that everybody who is employed by an enterprise is equally responsible for that enterprise. And I apologize. Could you repeat your question? I think I've lost the
conduct. I mean, that person, if I set up an entity and then I run it and use it, then I would be convicted under the conduct thing. I wouldn't necessarily be convicted under the participate in.
That's correct.
I mean,
Chief Justice. That's correct. But that is just an example of when you could have a person. Another way that you could have sole actors is in a RICO conspiracy. You can have a lot of different people doing a lot of different predicate acts, but if they have agreed that it's in furtherance of something, then their individual acts combine to form the RICO conspiracy. So we've never disputed that RICO applies to any person. I'm just saying that logically it doesn't follow that when you have a person acting alone who does not direct or control or even corrupt the enterprise that they're associated with.
And your position would be from a top-down standpoint, I guess, because obviously this officer was directing other people's actions within the enterprise.
I don't know if it's obvious that he was directing other people's actions. I think he took actions that probably caused other people in the enterprise to do things, but that doesn't mean that he was setting the policy or creating people's job responsibilities. No, he was simply a frontline officer, patrol officer. Going back to
what do you make of the so in the definition, if we took the state's approach, the positivist approach of just looking at the words on the page, an enterprise means in any individual. So if you do the algebraic substitution and just put individual back into the statute, what do you make of the idea? So it would be a crime then for any person employed by or associated with any individual to conduct or participate directly or indirectly in such, individual through a pattern of racketeering activity. Does that even make sense? Like, it doesn't make sense.
It doesn't make sense, and I think that would make it much clearer that there would have to be two actors who were working in concert, because we know that you can't associate with yourself for purposes of RICO, and that's one of the problems with the definition of enterprise is that when you look at the cases defining it, it is so many different things. And so a lot of the language in the cases comes from situations where they're talking about a quote-unquote RICO enterprise, which might include a business, an individual, an outside contractor, all of whom were acting together, and then the defendant is alleged to have associated or been employed by one of those parts of the enterprise. Here we have one actor employed by one office, and there's nothing indicating that the sheriff's office ratified, knew of, engaged in any of these acts, or even that another person knowingly did that. As soon as the sheriff's office had reason to investigate, they did so. They suspended Mr. Wester. They severed him from those tools of employment that may have been enabling him to commit certain acts, and so the enterprise itself remained completely distinct from any of the activity. And this is where I believe the purpose of the statute is important, not the purpose of combating the mob, but the purpose of combating the infiltration and corruption of legal entities, which is absolutely one of the reasons that both the state and federal acts were enacted. I think it's proper to do, as the First District did, to read those terms in light of what the statute is trying to accomplish.
Well, it seems like you've touched on what is an ongoing debate in the originalism space. And originalists are not allowed to mention purposivism because that would be different, and that's not allowed. But at the same time, how do you approach the original meaning without considering the context, which then is going to involve looking at why, what was going on, what was being addressed by the statute? So isn't it kind of circular for the state to take the position that the first DCA has added words to it or added an element and is impermissibly looking at the purpose? At the time in 1977 when the statute was enacted, there was stuff going on. That's context for the statute. So then can't we use that to understand what enterprise actually meant? And were they just defining it, or were they giving examples of these are the different ways that someone could be engaged in some sort of criminal undertaking?
I think in the context that you're describing, it is absolutely proper to look at the purpose of the statute, because that informs the meaning of the terms. And one of the reasons that I added the Dream Defenders case in supplemental authority was that that's an example of this court doing that, looking at the structure of the statute for clues as to meaning of terms within, but also being informed by what the statute was accomplishing. The same.
In that case, we were also looking at centuries of common law to understand the meaning of riot.
Well, yes, you had more to go on in some senses, Justice Curiel.
Just to be clear, though, you're not. There's the first part of this says it's unlawful for any person employed by or associated with any enterprise. You're not denying that the sheriff's office is an enterprise for that part of the statute.
For that part, no.
Okay,
absolutely. The sheriff's office is.
So it's not so much a matter of defining enterprise per se. It's participating.
It's
in
defining
the enterprise
participation.
Through,
exactly.
You know what I'm saying? So the whole thing about having absurd, absurd definitions of enterprise. It doesn't seem like that may be true in other cases, but it seems like that's not the problem here. The problem here is whether you can essentially be a one-person corrupter of an enterprise, of the acknowledged enterprise,
yes,
when no one else is really in on whatever it is that you're doing.
That's exactly the problem.
And isn't that what this is? Like if we know the legislature wrote this broader than what the original, the original mischief was, if you want to go with that. We know the legislature wrote it broader, and the legislature made a decision, very clear from the text the way it's structured, that it's going to punish people who leverage either illegal or legal organizations to conduct this activity in a pattern-like manner, which is what he did here. So I'm struggling to see, even if we take this, even if we're looking at it in context and we're looking at it with a purpose, why this is so far removed from a purpose or a conceivable purpose or the context that wouldn't be the type of punishment that the legislature is seeking to impose.
Yeah, respectfully, Your Honor, I disagree that the statute is written to punish those who leverage The statute's written to punish people who invest in, own, operate, conduct, or participate. To import the leverage requirement is just as much importing a requirement as to import a two-actor requirement. Neither of those things are explicitly in the statute. Both of those are concepts that help us get at the idea of what does it mean to participate in an enterprise. And is it enough that you simply used the tools of your employment? If so, anyone who commits a crime that was made possible in some way by being employed has committed a predicate act. And
how do you distinguish this from Shema, for example?
Shema is the most difficult case, and I acknowledge that case does not discuss the requirement of multiple actors. They may have been present, I don't remember, but the case discusses a single actor. All I can say to that is that our position is that the way that case approached the participation requirement is too broad, that simply using your position without some kind of acting in concert with another is not sufficient to create a RICO violation. It may and did create other violations in that case and this, but it doesn't rise to the level of RICO because there is no participation in the sense of acting with or with a joint purpose with some other individual or entity.
So you have, it seems like you have one of your stronger arguments is this idea of turning everything that someone does who's part of an enterprise, anything that they do, if they have enough of the predicate acts, it can become a RICO thing. But does your interpretation of the statute basically make the conspiracy part of the statute kind of redundant? I mean, is there anything that would meet your definition that wouldn't also be a conspiracy?
Yes, Your Honor. I think that conspiracy part of the statute is still necessary because particularly in an illicit enterprise or an enterprise in fact, you can have people committing different predicate acts that have nothing to do with each other. And so you can have people who don't commit the predicate acts but cause them or direct them or enable them to be done. If I knowingly give Joe a space in which to make usurious loans, or if I...
So it's for people who aren't part of the enterprise then? Anyone who's part of the enterprise, as to them, it would be redundant. But maybe if I'm helping, if someone,
I'd say somebody who's not who hasn't committed specific predicate acts, but who is part of the enterprise, that would reach part of the enterprise in that larger sense in the definition of an association of people working for some common purpose. So you wouldn't be able to avoid liability under RICO by saying, I never broke Joe's kneecaps. I never made that loan. I never bribed that official. If you knowingly participated in some way in making that come about, that's what the conspiracy is.
Why do you so freely concede that the sheriff's office is an enterprise?
Yes.
No, why?
Oh, why?
It seems to blow your entire case. Just to be honest with you.
We concede that it is an enterprise for purposes of that subsection 3, a person employed by or associated with any enterprise.
Right.
But what the sheriff's office is not, in the sense that many of the cases discuss, is a RICO enterprise, because it did not.
So what you're saying is that the sheriff's office could be an enterprise if used in some sort of criminal fashion. Say you would have a more difficult case if your client was working with the sheriff or the undersheriff or someone else in the organization.
Or if my client was the sheriff. That would be, I think, like the Ruiz decision. I believe that was an example of a sheriff, the actual sheriff misusing the office, because at that point the sheriff has the power to direct others to engage in the acts in furtherance of the
Well,
the
that seems to
enterprise.
confuse an abuse of power violation or a 1983 violation at the federal level. How do you otherwise make the distinction between 1983 and RICO if anyone that uses a government entity and abuses their power, I guess, is both a RICO violation and a 1983 violation? That doesn't make sense either.
No, Your Honor, it doesn't. And the reason that it would that would be true, I think, of the sheriff or the operator of an enterprise or somebody with, managerial or ownership control, is that is what RICO, one of the things RICO was designed to do, is to go after the corruption and the misuse or the acquisition of illicit interests in enterprises. But here, the tension that you're pointing out is this is the case where that arises, where you have somebody who simply is employed by an enterprise. There are other ways of penalizing the misuse of someone's position. And when there was no acting in concert, either with the enterprise or with other people within the enterprise, there simply isn't a RICO violation because nobody participated in the enterprise through the racketeering activity.
You can have 30 seconds to finish up.
I apologize, Your Honor. I just want to close by saying that the plain common sense meaning of participate does not reach as far as the state's position here. I think people reading a statute, understanding what participate means, would automatically understand that it assumes some level of concerted action, which means working together with others in a common purpose, and that simply was not present here. And so we have law violations, but not a RICO violation. If you have no further questions, thank you,
Thank you very
Honors.
much.
Well, Your Honor, I was happy to answer any questions that you may have, but otherwise I'd like to make a few quick points. First, about the direct or conduct test that opposing counsel was talking about, that comes from the U.S. Supreme Court in Reeves. We don't think it's applicable here. Very clearly, the U.S. Supreme Court was wrestling with the oddity that is having conduct twice in the same statute. But even if you did think it was a relevant standard, Wester here would meet that test for the same reasons outlined in Shema. But
sorry to interrupt you. Could you just address this point that if there are a sufficient number of predicate acts, that basically anybody who is employed by something that meets the definition of an enterprise and then abuses their authority, whether it's someone in a private business or a government person, that basically that also would be a RICO violation?
So if you just so happen to be employed and you...
I'm not saying I'm employed by the postal office and then I'm out like robbing 7-Elevens at night, but it's I wouldn't be able to do it without my job.
Then I do think you're very close, Your Honor. RICO by its nature is very fact intensive, so it does depend on the set of facts, but the state is comfortable with saying that in many of those instances it very well likely might be a RICO charge.
And should that, I guess, I know that the sort of stock answer to that is, well, go to the legislature and change the statute. But, if we're trying to kind of give a reasonable interpretation to the statutes, does that seem reasonable to you?
I do, Your Honor, and this gets to Justice Tannenbaum's point about kind of the reason behind the act, and I do think it's twofold. One, to give law enforcement greater tools to address organized crime, but two, in an era then as now of dwindling support and trust in institutions, to say we have an obligation to make sure that these institutions aren't corrupted, and Wester is about as bad an example as you can have of that happening. So
okay, thanks. Does anybody have any questions? Okay, you can have 30 seconds to finish up.
No. Your Honor, we're happy to stand on the plain text of the statute, and with that, we respectfully request that this court quash with instructions to reinstate the conviction. Thank you.
We appreciate it. Okay, our next case is Linden versus State of Florida, number 2025-0054. Whenever you're ready.
Good morning, Your Honors. May it please the Court, my name is William Pinnell, and along with Attorney Charles Fletcher at counsel table, I represent Jeffrey Linden, the petitioner in this case. Based on the face of the record, the United States Supreme Court's decision in Fiore versus White, and Mr. Linden's constitutional right to due process, he is entitled to have his PRR sentence vacated in this case. Pursuant to the plain language of the 2016 version of the PRR statute, as interpreted by this court in its unanimous Lewers decision, Linden's 15-year mandatory sentence is an illegal sentence subject to correction pursuant to Rule 3800A.
You can see that you've made that argument before.
He has made that argument before, but pre-Hutchinson, before Hutchinson came out.
Explain why it shouldn't be procedurally barred.
Well, a couple reasons. It's a new basis based on new case law, and the successive rule of Rule 3800A is discretionary. It says it may deny as successive. So
why should we? Or shouldn't we, I guess, from your perspective?
Because there's new authority that gave him the ability to make a new argument. He wasn't simply repeating, I think the successive bar is in place for someone that says, this year, I win under Apprendi. And then no new case comes out, no new authority, and next year says, I win under Apprendi. It doesn't explain any new theory, no new case law. I think it's not intended for...
Does any new case under Apprendi do?
It's a good question. People disagree about that. But I think, for example, I think Erlinger confirms what Apprendi means. So I think in that case, it wouldn't be new, but it would help understand what Apprendi means. But so in this case,
what was the maximum sentence? I mean, I know there were multiple sentences, but what was the maximum sentence in the multiple cases?
It was 15 years with the ability to earn gain time.
And were any of the sentences, did any of the sentences exceed that?
All of the sentences exceeded that. So they're
all the sentences exceeded 15 years?
They're all 15 years and they have to serve 100% without the ability to earn gain time. In this court's decision in Carter, they said those sentences are different and one's more onerous than the other.
So is it the part that you're claiming would make the difference is that a minimum mandatory has been added and
Correct.
That would not have been allowed without the PRR?
Correct.
So it's the minimum mandatory issue that makes it illegal.
Yes,
the minimum mandatory
and that's
part.
explicitly in the PRR statute, and in the Carter case that they cited in a footnote, I think it's footnote 5, that an HFO statute which precludes gain time and works as a mandatory sentence is more onerous than a sentence imposed pursuant to the sentencing guidelines or the criminal punishment code where you could get gain time.
So the motion to correct sentence, which is what you filed or what your client filed below, it would be to take off the PRR designation. That's the requested relief?
Well, I think the requested relief would be to be resentenced without...
Yeah, but that would be a 3850 motion, which you didn't. I mean, to get a resentencing, you'd have to vacate the sentence. This is a motion to correct sentence. That's why I'm just trying to understand the scope of what you're asking.
Well, I think there's a host of cases where individuals are granted resentencing hearings on Rule 3800A motions. So in that respect, I disagree with Your Honor. I think the statute here made the 15 years minimum mandatory and maximum sentence mandatory. So the judge had no discretion. I think the appropriate remedy, if the court agrees with us, is to remand for resentencing pursuant to the applicable score sheet, and then the judge has the discretion to either to sentence for anywhere from the bottom of the guidelines up to the maximum.
Well, see, then that's the problem with using 3800, because that sounds like an attack on the process that led to the sentence. That you're suggesting that there were certain determinations made that were incorrect. That, you know, in particular, the nature of his prior sentence, and he wasn't in DOC, he was at the jail. That sounds like a sentencing process question.
So I respectfully,
you're asking for resentencing because the judge the first time didn't engage, you know, he thought he didn't have any discretion and had a sentence at the top as a mandatory minimum.
So I would respectfully disagree. I think it's substantive in nature because this court's decision in Lewis said that unless you were released from prison, you could not be sentenced as PRR. So it's essentially describing the substantive element of the enhanced PRR sentence. So I don't think it has to do with procedure.
But isn't that a fact question, potentially, as where he served his sentence?
It is a fact question, except in a case where the face of the record, pursuant to 3800A, establishes that he didn't serve time in prison. And in this case, we have the state's concession that he didn't serve any time in prison.
Can I ask you about that? Let's take the concession, what you're counting as the concession off, because I don't know that they could, even if they conceded, I don't know if that's enough to say that they met the rule requirement. But can you tell me what you point to on the face of the record? Because my understanding in Hutchinson is there was something that showed he had been released from the jail. That's not present here, correct?
I don't believe so.
So what we have, so we're inferring from the face of the record, and I understand, you know, he was sentenced to 365 days, and I think something like that, and he had served 377. So it's pretty clear inference, but it's not necessarily a document. Is that correct?
I think that's clear on the face of the record.
Okay.
You may disagree.
So you can just infer on the face of the record.
I think that's a reasonable inference. No one's sending someone to prison when they've served more time than their entire sentence.
In theory.
And I think that's consistent with Lewis. And at every level of...
If they had known, part of the problem with this whole thing is this absurd thing. Lewis, if people knew that the law was that I have to take you to prison and physically walk out of prison,
No, not necessarily. I mean, the legislator made a choice that only people that went to prison were going to be sentenced as PRR. So that doesn't mean that their intent was anybody that got a prison sentence needs to be driven to the prison to automatically do it. The idea is if you didn't go to prison, and Judge Makar said this in his dissent in Wright, that that's a rational decision and reasonable. So I disagree that if had they...
That is totally speculative. I mean, we know what the legislature did. They immediately after our decision changed. So the whole, you know, you can obviously at different stages of reality make hypotheticals. But we know what you would think from common sense actually turns out true, which is that the severity of the crime rather than...
Well, I don't think we know. I think that's one inference, but that's not what we do in our system. We have a separation of powers. This court interprets the statute as written, and then if the legislature wants to write it differently, they can.
So on that question, I think if we were writing on a blank slate, I mean, even not writing on a blank slate, but it seems to me like all of your I don't see how if we're sort of stick to what we've said in the past. Why don't we use that sort of rationale? How we would describe, you know, the state of the law at the time of conviction, and then what constitutes by retroactivity. I understand all of that is complicated.
Sure.
It seems like you kind of don't really take it head on. You certainly don't go through any kind of that it meets our test.
So I would agree with Your Honor that Barnum is our toughest obstacle. I think the facts of Barnum are different. In that case, we have a statutory construction that said the defendant was entitled to a jury instruction on a knowledge issue, but that remained a disputed issue in Mr. Thompson's case. Here, we have what I think is uncontested evidence, undisputed evidence that Mr. Linden never went to prison. So it's not just that he was entitled to an instruction or a jury finding. We know he's innocent of that conduct.
But it's about the element. Really, it's interpreting the element. I mean, there's no way that we can have a workable that was reinterpreted had been disputed at trial. There's no way that could be.
Again, I respectfully disagree. I mean, there's countless decisions from this court and other courts in Florida that talk about, was it a disputed issue at trial? Is it a material dispute in this case? It's not a material dispute in this case that he was never in prison. So I think that's different. I also think the difference is the DCA decisions that came out before Luers, that Luers overruled, I think were not just erroneous, they were clearly erroneous. When you read the Luers case, unanimous decision from this court, authored by Justice Lawson, and he resolves the conflict in favor of the second DCA over the first, fourth, and fifth. And the number of times that this court says the language is unambiguous, it's a giant number.
That's just not what Barnum says, though. So again, I guess back to the Chief's question and this, line from Barnum, clearly the reversal of a district court interpretation of a statute by this court necessarily changes the law. How do we get around that, regardless of whether it's ambiguous or not?
Well, I think that's a legal fiction to say a statute that wasn't amended meant something. Meant one thing in 2016 and then another thing in 2018.
But to me, that's an argument as to why Barnum's wrong.
Yes.
Okay. So do you agree that we would need a receipt from Barnum?
I think that's one way for us to prevail is to receipt from Barnum, and I think you should do that. I think Barnum's incorrect. I think it's inconsistent with Fiore. I think.
You have to be wrong about that. Because Fiore clearly different states can sort of have different views on how they understand what the law is of conviction, and there may, I know that the way that Barnum described the quote-unquote laws consisting of the text plus judicial glosses on the text. I know that there's some people who kind of, as a matter of theory, sort of dispute that, but that's hardly like a crazy way of understanding the law. And Fiore clearly says when we are, the substantive rule is we're looking at due process based on law at the time of conviction, and in order to determine what law at the time of conviction is, we defer to the state. And here, Florida in Barnum said, okay, this is the way we decide that. So there's no conflict with Fiore.
So I respectfully disagree. I think Barnum mixes and does not apply a distinct test under Fiore, instead just uses the wit test. So I think when you use the Fiore test, and it's an undisputed fact that Mr. Linden never went to prison, due process under Fiore would apply regardless of whether you reverse Barnum. But if you feel the need to reverse Barnum, I think Barnum is wrongly decided. I think it's, again, a legal fiction to say that because one DCA incorrectly interprets a statute, and this court didn't say it was close. This court said it was blatantly incorrect, that essentially accused the DCAs of legislating from the bench and, quote, skipping the plain language step of the statutory construction analysis. So now we have a situation where if we keep the law as it is, you can have one rogue DCA, one 3-judge panel, you can have a 2-to-1 decision where they completely misapply statutory construction rules, and that's the law of the state.
Well, the problem, though, is that the court is making judgment calls.
Sure.
If your client had appealed and somehow gotten up to this court and we decided to pay. So it's really sort of, it's partly, I know that there are some phrases in there that are kind of you're talking about having that system that both finality and getting it right. All that I Barnum is saying is that look, in that trade-off, we're going to kind of, we're going to decide, did you, were you fairly heard at the time, and we have your appeal heard, and that's going to be the benchmark. And we're going to have these pretty stringent rules for overturning final, so it's kind of mixing two.
Yeah, so I understand, Your Honor, but I guess it's contrary to the role of this court in being the court that resolves conflicts in the law. So if this court resolved conflicts in the law like it did in Lewis, but doesn't apply the ultimate decision, we're the high court, you're the high court in this state, but that doesn't apply to someone because of a 2-year difference, that seems arbitrary to me, especially when you have an element that's not disputed. Again, if the knowledge element in Thompson was disputed, here it's undisputed he never went to prison. So I think you could carve it out and say that would only be the exception, where it's undisputed that on the face of the record he didn't go to prison. That's a due process violation under Fiore. Where it's a disputed issue, it's different. Again, when you read Justice Lawson's opinion, it essentially accuses the DCA judges of legislating for the bench, substituting their policy judgments for the legislature. So we're allowing rogue DCAs to make, quote, the law of Florida. And individuals have no control of that, and they're arbitrarily sentenced to a minimum mandatory sentence because of a 2-year delay in this court correctly interpreting the statute. And I would cite the Fiore case where it says it's a due process violation. It precludes conviction where the criminal statute, as properly interpreted, does not apply to conduct for conduct the statute does not prohibit. And that's what we have here. Lewis makes clear that the PRR statute only applies if you're released from a DOC facility.
But using, taking this principle and kind of drawing back a little, I understand in this case it was a rogue DCA, as you call it, and a 2-year. What happens if it's, all the DCAs and it's 10 years, and then maybe there's a conflict, or maybe there's a certified question that comes up? What if it's 15 years, 30 years? I mean, how would that principle apply? I mean, I understand in this particular case, it's a very short frame of time, and it was this one little issue, one rogue, as you call it, and we said it was very clear. But how, I mean, if we're going to take that as a general principle, how would where would the line ever be?
So again, one of the lines would be, is it undisputed on the record that the person is innocent of the element as opposed to a disputed? Another line would be, are the DCA decisions not just wrong but clearly erroneous, kind of like the standard you use to depart from stare decisis that this court used in Poole. It's not just wrong, it's really wrong. So there's no way you can read Lewis and not think that this court thought those DCAs were. What
if they were really wrong but for 20 years?
Well, I would hope that this court someone would ask this court to take the case, and this court would accept jurisdiction earlier than 20 years. I think that would be a very rare occasion that would occur, but if it did occur, I would think that Fiore would still apply. The other way we distinguish our case from Barnum is on the Witt retroactivity test. It's our position, if you apply the Witt retroactivity test, that this rule actually satisfies the requirements. If you look at page 525 of the Barnum opinion, they talk about the Callaway and Stevens case where lengthy sentences were imposed and there was due process concerns in those cases. We think our case is much more like Callaway and Stevens than Barnum. It's certainly based on a decision from this court We believe it's constitutional in nature based on fiore, and we believe it's a development of fundamental significance because it places beyond the authority of the state to impose certain penalties. Sure. We believe it places beyond the authority of the state to impose certain penalties. Lewis says you can't impose a PR sentence if the person wasn't in prison. I mean, that meets the plain definition of a development of fundamental significance. So even if this court doesn't want to receive from Barnum, doesn't want to apply fiore, the Witt test allows this court to find Lewis retroactive.
Thank you, Mr. Chief Justice, and may it please the court, Nathan Forrester for the state in this case. I'd like to start briefly by just, as you well know, there are two claims here, a Lewis claim and an Erlanger claim. I just want to briefly sweep aside the Erlanger claim. I think there's no question that is unpreserved, and this court has clearly said in Wainwright that Erlanger is not retroactive. So unless you have any questions about that element of his case, I propose not to spend any more time on it. I would spend all my time on the Lewis claim. And as to that, there are three problems, and this court touched on all three of them in its questioning. The first is that the fact of his release from a county jail is actually not apparent from the face of the record, which is necessary for a 3800A motion. 3800A requires that the court records demonstrate on their face that entitlement. All they say here, the record, is that Linden was committed to DOC custody and remanded to the Brevard County Detention Center. There's no indication where he was released. Based on
it seems like below. State wasn't contesting that.
Well, because it's a 300A motion, we didn't have the opportunity to contest in an evidentiary hearing the site of his release.
You didn't say you even needed.
Basically what we did was accept for purposes of argument his premise that he'd been released from a county jail, but said that still didn't suffice to give him relief under Luars because Luars wasn't retroactive.
So you never, the idea that this is a
I believe that is correct, but we have the advantage of Titsy Kosman to do that. We have the advantage of Titsy Kosman to do that, to raise it for the first time.
On that, do you think that some of this confusion stems from the mess that this court has made over the interpretation or meaning of 3800A? It seems like the court's been all over the place over time on how it's supposed to be applied, and it seems to manifest itself here. We always talk about face of the record. Not sure what that means other than if you look at 300A and you look at what this court said as recently as in Morgan in 2022, we made the distinction between a 3800A and a 3850 motion. 300A is a correction of the sentence as part of an ongoing sentencing process. 3850 vacates the sentence and gets you a new sentencing because you no longer have a sentence. It sounds like 3800A properly applied would be if you look at the face of the judgment and sentence and determine that it's illegal in some way or there's some error, or you look at the score sheet as well. I'm just saying that you made this argument. That seems like that doesn't apply here. Like what they're arguing is a little bit more than just if you look at the judgment and sentence. It's actually if you go back and look at how he served his sentence and all that kind of stuff. It sounds a lot more like a 3850 motion than a 3800.
Yeah, I would agree.
What do you
this
think
should have been brought as a 3850 motion, but obviously he would have been out of time to do that, so he brought it as 300A.
Sure,
but
that's the mess that we've created. Is so we've created this outlet that probably shouldn't be there. I mean, if we're going to set time limits to get finality in judgments and sentences and reserve these corrections for what are clearly illegal on the face. You look at it, it's a third-degree felony and he gets 15 years. Clearly that's an illegal sentence that needs to be corrected, and it can easily be corrected by a trial judge. But now we're in this mess of, well, we have this other argument, it sounds like Apprendi a little bit, but maybe not, and they get a second crack at it, or in this case, a third crack. Should we clarify what the meaning of 3800 is?
I don't think that it is necessary for this court to do so. I mean, I'm not here to cast aspersions on this court's 300A jurisprudence. I take your points. I do think 300A has at times been interpreted a little bit too broadly, and we've separately argued in the May case that it shouldn't be a vehicle for bringing Apprendi claims, for instance. But you don't have to go there in this case to decide it. The simple fact of the matter is the court records just don't demonstrate on their face that Luars is entitled to relief, because they don't. The fact of where he was released from is not actually shown. Counsel conceded that this was an inference that he was drawing from the record, and it's not fair.
But you've conceded that this is the first. I'm not saying it's a bad argument. Just you said that this is the first time you've made this argument at this stage of the litigation.
It's the 300A as a poor vehicle, yes.
Okay, good. Okay, so the second thing about the successive issue.
Mm-hmm.
Do you read? So it says it may be dismissed. Just the trial court here chose not to dismiss it. Do you view it as under the rule? Can we just kind of say at this stage, hey, we're not saying that it was an abuse of discretion necessarily for the trial court not to have dismissed it, but we're just going to invoke that and dismiss it ourselves now? I mean, do you have any, A, do you think that that's something we can do? Is there any precedent for us doing something like that, or a DCA doing something like that?
Well, I definitely think that this court, the language of the rule is permissive, and I do believe this court can dismiss on successiveness grounds. Even if the trial court didn't invoke that ground, this court, I do believe,
I know that if it had been an error for the trial court to have let it go. I mean, I know that if the rule said, the trial court must dismiss it if it's successive, obviously we could then, but can we just sort of say, well, we're not saying that you were wrong to have done it, but we're going to do it?
We're not saying that you were
wrong, that you abused your discretion by hearing it, but now we're going to exercise discretion to just
I honestly don't know why this court couldn't. Again, it would be, we can seek affirmance on any ground that's available. This court would be within its discretion to do so. The rule is phrased permissively, and I do think this 300A motion was successive. He sought, his ground for relief is exactly the same as his first set of motions. He sought relief under Luars.
Can you respond to his argument about the subsequent change in law, and whether that gives him any new bite at the apple?
There was not actually any subsequent change in law. First of all, Hutchison's not saying something new. It's effectively an application of Fiore and Bunkley, which are cases from the early 2000s from the U.S. Supreme Court. I actually found there's a 1994 case from the second DCA called Callaway, in which they articulated this exact same theory that somehow 3800A blows the doors wide open and relieves the court of any need to do retroactivity analysis. And we obviously think that's very wrong. But that theory's been floating around for some time. Hutchison didn't break any new ground on that front. That's just the excuse he is making for bringing a successive motion. So the ground for relief is the same. I don't see any reason to encourage this kind of piecemeal, presentation of different theories to support the exact same claim in 3800A motions. But from there to the merits of this, which is far and away the most interesting part of this case. He didn't really bring any kind of a WIT retroactivity analysis in the briefing. He now seems to be doing so today. He seems to be suggesting that this case would in fact be retroactive under WIT when it is a standard statutory interpretation case, and WIT clearly says it applies to major constitutional changes. So unless we are going to go back and basically revisit the whole WIT standard, I don't know what the basis would be for arguing that we'd entitle him to relief. Plus the fact, at a minimum, his current motion is successive on that front, because that's exactly the claim he brought in the first set of 300A motions. That's basically law of the case at this point. That Luers was not the law that applied at the time of his original PRR sentences.
I think the argument is more that it's a Fiore issue, so it's not retroactivity, it's change. And what would your response be to the argument that Barnum has completely misinterpreted what a change in law is, and that it creates this rule where one district court can go one way, and I guess conceivably there could be a change in the law in one district and not the other under Barnum. So do you think that Barnum's interpretation is correct as to what the law is?
Yeah, I do believe Barnum is correct. It's also confirmed by the Bunkley case that came out, the Bunkley case on remand from the U.S. Supreme Court to this court a few years earlier. I'd also quote this court's more recent decision in State v. Johnson, which was the case that said that Blakely wasn't retroactive in a 3800A motion. The court actually said that if the result was not dictated by precedent existing at the time the defendant's conviction became final, it's a new rule. So that this court has, in multiple cases, followed this approach, which deems the law for purposes of assessing whether it is a legal sentence under 300A as the statute plus the body of precedent interpreting that statute. You can't take the two apart. I understand that in a sort of a grander philosophical sense, the active interpretation is always figuring out what the law meant from the beginning, all along. But for purposes of this 3800A vehicle, for purposes of due process under Fiore, purposes of retroactivity analysis, it's necessary to take into account the intervening body of precedent. The theory that he's advancing is basically, it sounds like the Pariente concurrence in Barnum, which even that concurrence conceded that if every DCA had gone one way and then the Florida Supreme Court came out a different way, that would be a new rule. And that's actually what we have here. At the time of his conviction, it wasn't just the fourth DCA in the 2013 case in Taylor that had held that Luers didn't apply to at the time of relief. It was the first DCA in Wright, I believe, and the fifth DCA in Luzon, and no other court had gone another way. It wasn't until the second DCA in Luers came along and conflicted that this court then addressed the issue and cleared it up. So at the time of Lyndon's conviction, there was unanimity. Sorry, I misstated what the issue was. There was unanimity on whether a county jail, a release from a county jail was sufficient to trigger a PRR sentence. So he also, sounds like at times that counsel is inverting to something like the old Clayman standard, which invites the court to engage in an analysis of whether the statute was truly unambiguous beyond any room for argument. And his court clearly abandoned that approach in Barnum, I think correctly so. But even if it were to go down that road, the state obviously had good faith arguments for why they thought a release from a county jail was still constructively for release from a state detention facility. The defendant in those cases was still being remanded to the custody of the Department of Corrections. And it was only by happenstance that the defendant was then going to the county jail and being released. The standard language on the sentencing orders, and it's just true in this case, would actually say you are to take direction from the Department of Corrections as to what facility to put him in next. And in the Luers case, they actually had record evidence that the inmate had signed a form provided by the Department of Corrections, a release form, at the time he got out of the county jail. And so that clearly contemplates the possibility, at least, that he could have been released at another location. And it goes back to the point that we don't know where he was released from, but it also goes to the point as to why it was reasonable for the state to have argued as it did up to the point that Luars decided differently. And so I don't think even if this court were to retreat to the Clayman ambiguity versus unambiguity line, it would be possible to say that this was a statute entirely free from ambiguity. That would be news to all the DCAs that had gone a different way prior to this court's decision in Luars.
That would make our jurisprudence in this area as bad, apparently, as our 3800.
Can I take you back to the 3800A questioning again? It strikes me, we're talking about finality. Typically, a trial court loses jurisdiction over its judgment and sentence once all the process plays out, subject to authorizations from this court to revisit that, either open up the judgment through 3850 or open up the sentence through a 3800. What was on appeal to the 4th DCA was the denial of a 3800A motion. The DCA affirmed that, and now that is being sought, there's review being sought here. Why couldn't we still affirm the 4th DCA affirmance of the denial of that 3800A motion and address the jurisdiction aspect of it? Even if you didn't, you didn't initially raise it, but if it's the trial court lost its authority and we didn't intend on giving the trial court the authority to address this kind of motion or revisit a sentence in this way, can we say that and affirm the 4th DCA?
When you say jurisdiction, you mean that Rule 3800 was not an available vehicle?
Right, and because the 3800A motion, by our rule, is an authorization to the trial court to revisit that sentence, which otherwise would be untouchable.
I think this court could do that, yes. I don't think it needs to, but it could do that.
And our precedent has never talked about that issue as being a jurisdictional issue. I'm not saying that as a matter of starting from scratch that it maybe could be characterized that way, but that would be adding yet another. It'd be kind of like in the certiorari context where there's the jurisdictional component and then there's the substantive thing. We would just basically be layering in another kind of analytical sort of thing that we'd have to go through. I mean, that would be breaking new ground.
I actually thought about this question in the run-up to this argument, and I wasn't able to get a clear answer on whether 3800 as a concept was a jurisdictional limit or almost like a cause of action in a sense for a defendant post-conviction, and I couldn't weigh in on that, but you may well be right, Chief Justice. So. I want to address finally this suggestion that seems to be at the bottom of his brief and seems to be animating what the 2nd District has done in Hutchinson and in previous cases, which is to treat 3800A as if it entirely dislodges the need for retroactivity analysis under Witt or, I guess, due process analysis under Fiore. The 3800A basically means you just look at whether the sentence is illegal under the law as it now has been defined, and if it is, you get relief. That's 300A. That overly simplified version of the statute is unlike anything this court has ever done with 300A. That would blow the doors wide open to 300A, allowing for post-conviction relief every time this court issues a new decision and in any way purports to reinterpret or even comment on interpretation of a statute. And this court in the 2013 case of State v. Johnson warned of precisely this problem. That case, again, is the one where it determined that Blakely was not retroactive. There was not, and it further determined that Blakely was not a mere clarification of Apprendi for purposes of the the purposes of the Fiore due process analysis. And the court warned in there, this court specifically warned in there that the first DA's rather casual determination in that case that, well, we just view Blakely as a clarification of Apprendi. It's stating what the law meant all along. So that determination by itself would lead to this scenario where they actually use the phrase open the floodgates to post-conviction claims being brought on every time the law changes. That just can't be the current scenario. This court has never countenanced that. There's nothing in Fiore that demands that. Mr. Chief Justice, you're exactly right. The Fiore decision defers to the Pennsylvania Supreme Court's determination of whether that Scarponi decision was new law or merely a clarification of law. It deferred to the state. It's a question of state law. It's up to each state to determine its rules in this area. What is, in fact, going to apply as a matter, what is, in fact, going to be the law that counts for purposes of post-eviction relief? And I think this court's precedents on 3800A in defining what is an illegal sentence make clear that the law consists of the statute plus the intervening case law up to the point of a reversal by this court. And if, like in Mr. Linden's case, when he was sentenced, all the DCAs said that release from a county jail was constructively released from a state prison facility, then he got the law that applied to him at the time he received due process. And so his Fiore claim cannot be accepted.
Does anybody have any questions? Okay, do you want to, is that it?
No, I thank you, Your Honor, and we obviously urge affirmance.
Thank you very much.
May it please the court, two things. I think the flaw in the state's argument is, we're here on a conflict between Hutchinson and Linden, and they say Hutchinson applied Fiore, but they don't tell you why that's wrong. So I think they have not explained why Hutchinson is the wrong way.
Well, he just did. I mean, that was the last thing he said. You may disagree with him, but I mean, he...
Sure. Okay. But additionally, I disagree with Justice Tannenbaum's 3800 questions. I think this court has established a narrow definition of a legal sentence, which is a sentence that cannot be imposed under any set of circumstances, and that it can be raised at any time. And that's what we have here. And under the most important part of Fiore is statute at quote as correctly interpreted, and that's the Luer's interpretation. So based on that interpretation, this sentence is illegal, and we'd ask that you reverse and grant Mr. Linden a new sentencing hearing.
Okay, thank you very much. We'll be in recess for 10 minutes.
All rise. This honorable court is now at recess.
I just wrapped it up. I did. I don't know. It might have just walked down a second ago.
If I go around and check it.
Yeah. Go on.
Supreme Court of Florida is now in session. Please be seated.
Okay, our last case today is Gregor versus Rogers, number 2025-0246. Whenever you're ready.
May it please the court, my name is Lauren Levy. I'm counsel for Gary Gregor, who is the current Walton County property appraiser. I would note this case arose under the time period of his predecessor. With me today at the council table is Sidney Rotke, who helped me with the briefs and preparing for oral argument today. And I believe I reserved five minutes for rebuttal. Your Honors, this is a property tax case, and it involves primarily an issue of statutory interpretation. And under this court's recent decisions, that requires that we focus on the text of the statute at issue. It requires us to understand the context in which the statute was enacted or passed, and it entitles us to consider the entire statutory structure governing property tax exemptions and denials thereof. It's our position that when you look at the 2007 amendment to 196-193-5 subsection B, that the intent of that amendment was not to override or supersede or insert additional language into the pre-existing statute that we had for denials of homestead exemption, which was 196-151. And the temptation I think I would have would be to start with the 2007 amendment. But I would like to indulge the court just for a moment and talk a little bit about the history of how we got to where we're at. We've had this homestead exemption approval, refusal, hearings statute. That's the title of the statute since 1935. We've had that all the way through until today, so that's what, 90 years. That statute has remained remarkably unchanged during that time period. There's been minor changes as to the deadlines for an application, deadlines for when the property appraiser is to act on that application. You used to have an automatic appeal to what's now known as the Value Adjustment Board. Now you just have a right to an appeal to the Value Adjustment Board. But that statute has remained markedly unchanged for a very, very long time. Moving forward in time, you would next look at 1971. What was important about 1971? Well, in 1968, the Florida Constitution changed. With particular regard to exemptions, the Constitution went from the 1885 Constitution that was viewed as permissive. The legislature could pass such exemptions it felt would be in the best interest of the citizens, to a Constitution of limitation. The 1968 Constitution says, here's our certain exemptions that there shall be, here are exemptions that the legislature may enact, and otherwise the legislature would have no authority to act. And so on the backside of that 1968 constitutional amendment, you have a very large rewrite of the entirety of the Florida ad valorem taxing statutes, including the exemptions. So in 1971, what happened was we renumbered our homestead exemption denial statute, 196-151. We added a new exemption denial statute, 196-193. We added an application statute, 196-011. And we have a Value Adjustment Board statute, which is the administrative entity that can consider appeals, that was also enacted in 1971. And all those pieces are going to go together here, I hope, here in just a second. So when you look at those statutes and when you go through time, you'll find that we did not even have an exemption application statute for exemptions other than homestead exemption until 1963. You had no separate exemption denial statute until 1971. In 1971, we now have a homestead exemption application, approval, refusal, hearing statute, and you have 196-193 that says exemption applications reviewed by the property appraiser. That statute, 196-193, simply said you had to give your denial in writing by July 1 and advise the taxpayer of the right to proceed into the value adjustment board.
Statute, denial of what?
What's that?
Denial of what?
Denial of exemptions under this section is what 196, 195 said at that time.
More specifically, because this is a county that there are no annual applications, right? In Walton County, at least.
This is a county where the Board of County Commissioners has elected to move to an automatic renewal of exemptions.
Right. So there's no application involved here annually. It's automatically the exemption is renewed every year. But the statutes that are at issue here, both in 193 and 151, talk in terms of the application being denied. But there is no application. So doesn't that actually help your position? And why wouldn't 196.011.10 by itself apply and get you to where you want to be?
Well, because I think it's been attempted, the Genesis Ministries case in particular, where the property appraiser tried to distinguish a removal of an exemption that doesn't have an original application for that year from an instance where you have an original application for that year and you act on that application. And the court said there really should not be any difference. And I've worked in this area a long period of time, and that seems to accord with my understanding of how things would work.
Is that a Supreme Court? Because I mean, I had the same question. Just it seems like there's a gap in the statute.
Yes.
Now I understand. I hope you keep going through your history because it's very important and interesting. But it seems like because this, giving counties the option to let people not have to apply, that was sort of an add-on, and it seems like maybe there wasn't a corresponding addition made to address what you're supposed to do. I mean, I see that there's the thing about the penalties if the homeowner doesn't let the appraiser know of the change. I mean, that's a big deal, obviously, but where does it? So was that case a DCA case or a Supreme Court case or what?
Yes, sir. That was out of the First District Court of Appeal. Genesis Ministries versus Brown. There's two of those decisions.
Okay. So anyway, if you want to go ahead.
But I think it's important. But going back to your question, in 1971, we had no automatic renewal mechanism for any exemption. We had a renewal application, which was basically a postcard that you would get in the mail, and you would have to sign it and return it. So in short, it was called a short form application. So there was being an application filed each and every year, and that when the 1971 statute was passed, that was part of the process, but there was no automatic renewal.
So can you, just to close the loop on this,
yes, sir.
Let's say that we ignore the fact that nobody has argued this and we say, look, we're fighting about 151 versus whatever the other one is, and it turns out neither one of them applies. We're kind of in limbo. Where does that leave this case?
I think it leaves the case that the property appraiser still has to advise the taxpayer of what is the action that's been taken for that particular tax year, because Florida's an annual assessment. You couldn't just take it away and not let them know.
But would you say that that the notice that was given here would satisfy whatever? I mean, first of all, is there a statute that we would be applying, or are we just kind of making something up, or what would we be doing?
There would not be any statute that would say when the application is being automatically renewed and the property appraiser denies, this is what, it's not in that specific context. No, sir.
Okay.
So, I would go back to, we have a very specific statute for homestead exemption, approval, refusal hearings. It has the requirement that we have to give the reasons therefore by a certain date. That would be the controlling statute under which to analyze the language. It would not be appropriate to bring forward the language that was added in 2007 into that provision. So if I go to 1971, so then we have these three statutes, and we had the Value Adjustment Board statute, and the Value Adjustment Board is the limited jurisdiction entity. And how is this jurisdiction described from 1971 till current day? It is described as it has the ability to consider challenges to assessments, your value, and then it says you have the ability to hear complaints relating to homestead exemptions as provided for under section 196.151, subsection 1. Subsection 2 is appeals from exemptions denied or disputes arising from exemptions granted upon the filing of exemption applications under section 196.011. And my point is, from 1971 until 2006, we had two statutes that impacted exemption denials. One for homestead exemptions, other just a general category of exemption denials, and the Value Adjustment Board statute that allows the administrative appeal recognized that it would take appeals from either or of those two statutes. Then we get to 2007, and the legislature enacted the law that we have to wrestle with now. And the argument is that this new language that requires you to state the specific requirements of the statute, state the specific facts that you looked at, and draft it in such a way that a reasonable person would understand, that language now applies to, or should be read into, 196-151. And we have to discern what that language means. And when you look to it, I think the legislature has given us the very answer. Because in the enacting clause to the 2007 legislation, the legislature said that it was amending 196-193, requiring the property appraiser to explain to a non-profit organization the legal and factual basis for denying a property tax exemption to the non-profit organization. So how do you take that language and say, well, the legislature said that, but we're now going to say that very same... I'm sorry?
Isn't the problem that language is not in the statute?
Well, I would consider it as part of the statute because it's part of the title and the enacting language to that statute.
From a way that the statute, so when you think about what the law is, I mean, would we have to say that enacting clauses are the law and that what's in the statute is not a complete, what's in the statute books, the four statute books, is not a complete statement of what the law is in Florida?
I think as this court has looked at how to analyze statutory interpretation issues, it says we're going to look at the entire context of the enactment, and that entire context.
Yeah, we look at the statutory context.
Well,
but I
understand that, but the legislature is trying to give us clear direction in the statute that this is what we're doing, this is what we're accomplishing with this amendment.
The relevance of that, I think, is that it, I think that your burden is to persuade people just to be open to the possibility that the 151 is for homesteads and that this other one is for non-homestead. That would just be evidence that would kind of support your underlying argument that, yeah, this confirms, because it would show that the people, the purpose of the title is to say what is the subject, not to say what is the purpose, what is the subject. So it's just showing that the legislature agreed with your understanding of the status quo, which is that we are amending the exemption denial statute that applies to these things. So it really, at the end of the day, comes back to, is the 151 the exclusive thing for homesteads, or is this other one kind of comprehensive that applies to all exemptions, not just homesteads? And it seems like your best arguments on that have to do with this thing with the 3A, where it says that before you, or sub 3, it says before, or now it's 4, before you decide, you've got to say whether they met 3A and 3B. These things about whether they fit into the exempt classifications and whether the applicant requesting exemption uses the property predominantly or exclusively, those are things that just don't really, those aren't relevant questions in the homestead context. I mean, that seems like the strongest argument on your side.
Well, thank you. I think the entire statute reflects that language. You start at subsection 1, property exempted from the annual application requirement. That's a certain list of property back in 1971, and I would still submit that an automatic renewal is not an exemption from the annual requirement, but it talks about property rented or hired out for other than religious, educational, or other exempt purposes. The items in 3, predominantly or exclusively, that straight ties to 196-192, which is our exemption statute for denials of what I call institutional exemptions.
But what about 3A? I mean, whether the applicant falls within the definition of any one or several of the exempt classifications would seem to me to embrace more than just a religious or charitable organization. It would be an exemption.
Well, I think arguably it could, but then it picks up in B and C, further clarifying, if you would, with the what the ambit of the understanding is. And so, you know, when you look at our statutes and you put them together, we've always had a homestead exemption application statute, and now we have an exemption application statute and review for the other exemptions.
Would you agree that, so just looking at 3A, B, and C, each one of those ends with a period, right?
Yes,
so if your reading of the statute were correct, I could imagine that the legislature might choose to separate those with semicolons and say or, right? I read 3 as stopping at the conclusion of A or B or C, right? And so it seems to me perfectly consistent with the outcome that the taxpayers propose, that they meet 3A and that I end my reading there. I don't have to read 3B or 3C.
I would very respectfully disagree with you that. If you'll read the vast majority of cases involving homestead exemption, you'll never hear discussed as an exempt classification. It is an exemption that inures to the person based on their personal residency on the property.
Well, it's an exempt classification because it's a homeowner's exemption. Isn't that an exempt classification?
You don't see the homestead exemption referred to in such a manner. You do see the nonprofit exempt entity exemptions referred to in that type of manner.
Yeah, I mean, I think what challenge here is that in 71, you had this big rewrite. You have, for the first time, definitions being added to the statute. They're defining these religious entities and whatever. Homestead was not defined then. It is now. It seems like part of the challenge here is that I think that if you read the 1971 law, it really is hard to read that as kind of replacing the homestead thing for purposes of denial. I think one challenge that we have to try to figure this out is that over time there have been more things that have been added to 196.011. This thing has changed, and so now I think the distinction is kind of blurrier than it would have been. And so part of the challenge that we have is do we kind of respect the integrity of the separation that was there at the beginning, or do we kind of just open the book now and sort of try to make sense of this thing where I think that the boundaries between the two categories are much less kind of obvious just from looking at the words on the page right now?
So, Mr. Chief Justice, I would agree with everything you said. And if the legislature had not inserted in the enacting clause the nonprofit language, the issue before here, the issue to the property appraiser would be more difficult. I would acknowledge that. But we have always had a specific statute for homestead applications, review, approval, disapproval. We've always had that statute. And to come in and say in 2007, we now have a statute that governs all exemption denials kind of flies in the face of that. But what did the legislature do the very next year? In 2008, the Constitution was amended to allow what's called portability. When you stay in your homestead property, you have an assessment cap, 3% or CPI, whichever is lower. As you stay there, the difference between fair market value of your property and the assessed value grows. In 2008, the Constitution was amended to allow a homesteader to take that accrued benefit with them to a new homestead property. That's a homestead exemption application on the new homestead and a separate application for portability of the amount that you had accrued on the prior homestead. The legislature, in enacting 193-155 subsection 8, put in a statute for review, approval, denial of portability applications. And what language did it use? It used the exact language out of 196-151. Because it's a homestead-related, homestead-tied issue. If the legislature had intended, or if the language should be read that 196, 193, 5B now controls all exemption denials, why would the legislature the very next year say when you deny a portability, you use the same exact language as we have in our homestead exemption statutes? It seems very clear when you put those statutes together that we have two exemption denial statutes, and both operate within their own ambit. Now we have three because we have the portability exemption denial statute. Those two are inextricably tied together. The last thing I wanted to...
Counsel, under 151, though, Do the property appraisers every year sit and look at the entire roll, all exemptions, even the automatically renewed exemptions, and review them again to see if they're still valid? Because the statute speaks in terms of the property appraiser every year shall review all applications for exemption. And then it goes from there and talks about denials of applications and that kind of thing. How does that apply to automatic renewals?
In two ways, Your Honor. Number one, property appraisers, with the resources that you now have on the internet and firms that can do this type of research work, will search their rolls, existing homestead rolls, for people that may have a Social Security number that doesn't match or have a homestead somewhere else. They're always looking at updating that information.
So they review all exemptions?
What's that?
They review all exemptions every year?
They don't pick up and look at each application, but they will have firms look out and scour their homestead exemption roll to see if there's some inconsistent data that requires further review. And the other way, what I would call the old school way, is what happened here is sometimes you get anonymous complaints that people are no longer in their homestead property. I believe I'm into my rebuttal time.
Can I ask you one last thing before you sit down? Is there anything that we could, so I think if you're right about this, then 151 has always, in this world, in your kind of tax world, 151 would have been thought of for homestead, and this other provision would have been thought of for the other stuff. Is there any objective information that we could look at to see whether property appraisers just in general have, as a matter of practice, proceeded under 151 and not gone through the specific facts that are in more detail than what this form does? Or because it seems to me like, if you're right, that we should be able to kind of just see from the way the world has been operating whether in fact kind of the practice and the mindset was just proceeding under that provision, or if they were doing something different.
Well, none of that factual information would be in this record, Your Honor. But this statute has now been around since 2007. The Rogers decision has been out a couple of years. I advise property appraisers. We tell them about the decision, and you certainly would say you may want to consider, in an abundance of caution, add more to your homestead exemption applications while this case is out there pending.
And before 2007, there was no daylight between what an appraiser had to say for denials under 151 versus under the other?
No. In fact, it was more specific in 196, 151. We had to give the reasons therefore. Until 2006, the other exemption denial statute just said you had to do it in writing by July 1. Nobody argued that, you should take the more specific language out of the homestead exemption denial statute and apply it to institutional exemptions. I do want to reserve the remainder of my time.
Okay, thanks.
May it please the court. I'm Nelson Hagan, here with Janet Varnell and Warwick on behalf of the Rogers family. This obviously concerns the termination of a long-standing family homestead exemption here. The legislature has given specific statutory requirements for canceling or terminating an ongoing homestead exemption, which also applies to initial applications too. We talked about 151 and how it dovetails here. And the Department of Revenue, who is in charge, the legislature has delegated to them the authority to provide procedures throughout the state to property appraisers. And they say, and they will tell you in a little bit now, we use the same standard for everybody. We don't want to reduce the homestead applicants to the second-class citizen, which is what would happen if my learned friend's proposition is put throughout the state. Most property appraisers follow the Department of Revenue's guidance and provide this information for their homestead when they terminate a homestead here.
Can you answer their argument that when we look at the statutory requirements about say a charitable or religious organization, it would make sense for there to be a recitation of specific facts, because those facts are collected at the front end when they're applying, whereas a homeowner doesn't really have to show any specific facts constitutionally or statutorily to qualify for the exemption. It isn't a matter of specific fact other than this is my homestead and I reside here and no place else.
Well, Your Honor, you've hit on the distinction with 151. What makes it separate and the Portability Act separate is those are unique transactions where we're saying, here's my qualifications to have a homestead in Florida. You know, I reside here, my children go to school here, whatever it is. And it's a unique transaction where when the property appraiser says, no, you don't qualify, it's in one compact transaction. So 151, that's why 151 and the Portability Act have separate notice provisions because it's related to one red row full of information. When you terminate a homestead exemption, there can be many reasons for that. In this case, we have, we have a random tip that you are renting out your homestead. Well, there's actually a statute which says what constitutes a violation of that homestead. So it is exactly the information that you point out that is more involved, requires more thought and analysis, and is why the homesteader should be entitled to that same information, and which is why the Department of Revenue says, yes, they are entitled to that same cancellation dignity that we give to a Lutheran high school or to the Goodwill or to a shipyard in the case of the Gulf Marine case.
Can you tell us it's your client, I have to say, the legal thing is what it is, but it's a pretty unsympathetic client who says, I'm not going to fill out your questionnaire. I knew exactly why they were denying me, et cetera, and now you're coming and saying, well, so tell me what would happen. So let's say, they give you notice, and let's say that all you get is the notice that was given here. Just, you've abandoned it because you rent it or whatever. I'm assuming that there would be an opportunity before you actually had to go and litigate in front of the board. You'd know if there were going to be more details, you would know, right?
Well, there was, Your Honor. And in what do you call the unsympathetic client, as you might take judicial notice, some Florida men can be prickly. And the information that was asked for, Social Security information stuff, that 15 years ago, we had identity theft was a problem, and he took the option that was in that letter, call us to discuss it, and he did. He did. What are you talking about, rental? I'm here. Come look. I invite you to come see that we're here residing on our property. And they refused to do that, which at first I thought, well, why would a manager come do that, until I found out that Walton County has 9 full-time outside property appraisers whose only job is to go out and check on the use and the status of properties. So the invitation was there, come check, come do this. The refusal to do that, I think, maybe makes colors the circumstances a little bit different.
But the point is, there's no question that your client was given notice of the denial, was told the statutory basis, was told, you rented rental of homestead to constitute abandonment. Obviously, I'm not saying that it complied with the statute, that's why we're here, but you obviously had notice, and this is a completely kind of form over substance thing that we're talking about.
Well, actually, Your Honor, I would respectfully disagree, because the statute that is being referred to, rental constitutes abandonment, that's the title of the statute. And that's why the legislature has required, you have to give the specific facts under the statute that they're not obeying. And in that actual statute, the requirements are he has to have rented all of his homestead for 2 years in a row, more than a month in each year. And that so-called abandonment stops when he comes back to his property. So the actual title is false. It's certainly misleading anyway. So it does not specify what the statute requires that they give him. And even more glaring, I think, is the refusal of them to even have any facts that any of this happened. There was no indication, there was no fact, they never were able to come up with any fact that he'd ever rented any part of his property, let alone for 2 consecutive years. So
Counsel, what about the aspect of that I was asking about before, both of us were asking about before, that when you look at both provisions, 151 and 193, both speak in terms of grants and denials of applications and getting notice if there's a denial of an application. And in your client's instance, they haven't submitted an application in a variety of years. So why wouldn't it just be under 011 sub 10, where the property appraiser can investigate, like you mentioned, and give you a notice that there's arrearages that your client's going to owe?
Right. Well, 011 is explicitly incorporated into 196.193. That's in the very first paragraph. But this applies to all exemptions under .001. .011, excuse me.
Well, what it says is that anyone that's exempted from the application requirement, their property assessment will be returned. So basically, they just get the exemption for another year. That's what that provision says.
Right, and that's the procedure, and that's why, because it's ongoing,
But that's not the same as an application. That's like just automatic. They get renewed. So if the legislature wanted to treat all of these the same and give notice to renewal, like, you know, if you're going to lose your renewal in some way, which is really, you've been granted your exemption, and actually you're now being accused of violating that or not giving notice to the property appraiser. That sounds a little bit different than an application process, which the statute goes into detail about how those are to be handled.
Well, and that is a nuance there, which is why the Department of Revenue points out that 193, if you comply with the notice requirements there, you've also complied with 151.
Yeah, but what if neither one applies in a situation where there hasn't been an application? Then why are we talking about either provision?
Well, because I think 011, if you read it, contemplates this, you want to call it automatic application, the automatic rollover of...
Well, it doesn't speak in terms of automatic applications. It just says, you know, you don't have to submit an application every year.
Well, that's correct, Your Honor, and that's the status in Walton County. Is, you know, some counties are an opt-in. You have to check off, yes, I want back in, which could arguably be an application. In Walton County, it's inform us if you're not here anymore. So it's an opt-out, which would not be an application. It's an automatic renewal unless you opt out.
Right, and that notice would be under 10A, you know, under 10A or under sub 10, where the property owner is required to notify the property appraiser if there's a change. Otherwise, they continue to get the exemption.
That's right, Your Honor.
And why isn't that sufficient to cover, you know, these situations, and you dispense with the whole very specific notice requirement? And if you miss one of those, then great, you know, you win. You know, it's kind of like, you know, a gotcha for the property appraiser.
Well, it's not a gotcha, Your Honor. The legislature has, these are protections that we need so that we don't have property appraisers canceling homesteads because they have a suspicion or because they have an anonymous tip. The legislature requires the appraiser to actually have facts so they can apprise the homeowner of those facts. And that's all. That's not a gotcha. If you don't have facts, which they did not have here, it is a gotcha to say, we've cut off your homestead. We are seizing all the benefits of the Save Our Homes Act that you've accumulated from 25 years of being a resident. We're taking that for ourselves with no basis that we can articulate.
So if you're going to apply those statutes that are based on applications, in a situation where it's an automatic renewal, those statutes, in some way, they have time periods that run from the application date in some way. Or when would the date run for situations where there's automatic renewal?
Well, in this case, the appraiser makes their decisions by March the 1st of each year. They start making those decisions.
What if they get a tip in April?
I'm sorry?
What if they get a tip in April?
Well, they have until July the 1st. To do it, and if they don't have it,
but the statute speaks in terms of the application, or the year that the application was submitted. So if you don't have an application, how do you know when to run the time from?
Well, the automatic, I guess, renewal system starts in March. That would be the time when it would start. And if they can't get it out by July the 1st, there's no penalty to them. They just have to wait till the next year to terminate if they think there is actual information.
And seek an arrearage.
That's true. They get a penalty, and they can get it's a 18% interest, and I think it was just increased to 100% penalty. So that's true that they can win if they're right on that kind of thing. But in this case, they don't have to be right, according to their proposition. And if I can just add, in addition to the Department of Revenue invoking this interpretation that we're arguing for, and it's, the argument of going outside, or to go out into the wilderness of history and tradition and supplementations, all that doesn't come into effect in our statutory interpretation if we can't figure it out from actually looking at the words.
Well, can you respond, though, to his contextual argument? It was based on the statute that this, homestead exemptions wouldn't naturally fall into exempt classifications, so that's an awkward fit to cram homestead into there, and that, if you look at 151 and 193 together, it starts getting a little repetitive. So just from a statutory context, without the enacting clause, why is a homestead exemption fall into exempt classifications? Start with that.
I think 151 is an artifact from the 1930s when you had, the property appraiser might have a handful of applications every year. Things are very different now, and the requirements, the safeguards to prevent arbitrary or whimsical cutting off of the homestead, which has traditionally been a very highly valued tradition in Florida. That's something that has constitutional protections. We infer statutes in favor of keeping the exemptions as opposed to against them, which we do in many instances. If I can say, the legislature, in passing the Taxpayer Bill of Rights a few years ago, has at the very end of it, it says that the right to notice of a denial of an exemption is one of the Taxpayer Bill of Rights that the legislature enacted, and they refer specifically to 193.5. They do not refer to 151 at all. So we have the reinforcement by their delegation to the Department of Revenue, who says this is the interpretation. And the law from this court traditionally has been, if you have an administrative body that's entrusted with implementing this law, we defer greatly to them. But basically, we accept their authority unless there's some reason not to.
We had a constitutional revision on that aspect as well. Administrative deference. Anyway, go ahead.
Should we defer to them on whether this was sufficient notice even under 193, which they think it was?
Sorry?
They think that this was sufficient. They think 193 applies, but they think this was enough notice that it complied with the statute. So should we defer on that?
They were not delegated the authority to make factual determinations over this. The notice was admittedly not sufficient. The property appraiser says, no, I don't put the specific facts on there. We don't do that. Which is, if they did it generally, but just messed up in this instance, that would be a different thing. But their procedure is not to put the specific facts from the statute in there, and their procedure is not to put the specific facts that would demonstrate a violation of the statute in there. That is their practice, and they admit, this is in our summary judgment testimony, we have depositions of them where they say, no, we don't do it. So to argue, well, they did comply with the notice requirements when in fact they acknowledge they didn't. And when you actually look at it, you see, even though they give an image of it, well, rental constitutes abandonment. But that doesn't give the specific requirements of the statute that would allow them to cut off your homestead.
It seems like, I mean, maybe your colleague can address this, but it seems like the department might be leading the property appraisers into repeated error. I mean, this form obviously doesn't lend itself to doing the kind of thing that you're talking about. I mean, I know you can attach stuff to it and whatever, but I mean, if the point is to standardize and make things straightforward and whatever, I mean, this form is almost inviting the property appraiser to do exactly what they did here.
Well, fortunately, Your Honor, we have staples and paper that can supplement the form. So it's not an onerous burden. If you have facts, it's a simple matter to reveal them.
And just to be clear, I mean, the notice says that the property appraiser thinks that you've lost this, but then you have an opportunity to actually litigate this and So really the idea, it's not as if the whole decision is going to be based on, with finality, based on whatever is on this form, right? There's going to be process for this. If the homeowner thinks, no, they're wrong, I haven't been renting it, or I haven't rented it the right number of days or whatever, that's what the whole appeal process is for, right?
Well, that's true, Your Honor, but just as, we wouldn't go to traffic court on a ticket that doesn't give a speed limit, doesn't give a time, doesn't give any information as to where you were going or how fast you were driving, we would say this has to be thrown out. There's no point in having a trial when there's no specific information to base it on. And in this case, as was admitted, they didn't have any facts that the Rogers family had ever rented any part of their homestead ever, let alone 2 years, 30 days, and all of the other requirements. So yes, hypothetically, there's lots of things that people could do differently. That's true. In this case, all we ask for is that the legislature requirements that they reveal specific information, and it's not onerous if they have it. If it's true, it is a trivially simple issue to reveal this information. We have information that your electricity was transferred to Utah and somebody else had an electricity bill there. There's lots of kinds of things that can be shown if there are facts. In this case, there was nothing.
Counsel, on that point, or to follow up on that point, it seems that under 011, it imposes a duty on the property owner to notify the property appraiser of a change in circumstances that would affect the exemption.
That's true.
And it also authorizes the property appraiser, if he or she finds that the homeowner failed to do that, failed to do the notification, they can pursue these penalties and that kind of thing. That's in 011, and no reference to notice or anything like that. So can the property appraiser still, let's say you won in this case, could the property appraiser still come after your client and allege that your client failed to notify and seek penalties?
If they had facts, absolutely. Absolutely.
So then why are we even, so this case is just about notice, and so this technical removal of the exemption, but the property appraiser could still go after your client on this issue for not notifying them about the rental, which he's apparently admitted to in some way.
No, Your Honor, he did not admit to it. He admitted that he knew it was about rental. It's like when you got the speeding ticket with no information. I know it's about speeding, but I don't know, anything else. There was never any revelation to him.
I just mean that based on everything that's taken place so far in the case, in the proceeding, there's nothing that stops the property appraiser from still pursuing your client for these back years, including the year that that the notice supposedly applied to, or
if they had information, Your Honor, yes.
And also, and you're worried about your Save Our Homes thing going forward.
I'm sorry?
You're worried about your Save Our Homes cap going forward. So you want it to be kind of, you want the 2017 thing to be right.
The legislature said this.
No, and you should be. I'm not criticizing you. I'm just saying that's why it's not just a completely academic exercise.
Right. And the legislature says this is the remedy. If you don't give a notice that complies, the notice evaporates. It doesn't create any new benefit for whatever the exemption was. It doesn't create an exemption that didn't exist, but it removes the impediment to that exemption continuing. And that's what we have here. We have an admitted failure to comply with 193. The consequence is that goes away and it was restored to the old time. The first court's analysis is pretty good, Your Honor, and they're sticking to the close text of the statute, I think, is what we need to be doing here, and not be hypothesizing about introductory paragraphs and history and changes. And as the Department of Revenue says, there's no reason to make second-class citizens out of our homeowners. They're entitled to the same benefit here. The Taxpayer Bill of Rights, another legislative reassertion of its authority to have these specific safeguards for our citizens. If I could reserve the 1 minute to reply to any adverse qualities of the Department of Revenue who is following me. which we've agreed to do. Is that
Okay, that's fine. 1 minute.
All right. Okay. Thank you, Your Honor.
Thanks.
Good morning. Randy Dinsher for the Florida Department of Revenue. With me is Tim Dennis, co-counsel. So I have an outline, and I prepared, but I'm going to start with the questions that have been presented. The Florida Department of Revenue has one form, as clarified by Mr. Rogers' counsel. The Department of Revenue has always had one form. 196, 193, and 196, 151 has always been interpreted in harmony, even before the revision in 2006. The only thing that happened in 2006 was the notice in 193 added the specific requirements that the four specific, well, actually there were three specific requirements added that basically gave a reasonable person due process notice.
From the department's perspective, are there any cases to which only 151 applies and not 193, or do all cases, yes, or do all cases fall into the regime that we're talking about at 196, 193?
All cases go through this note, an exemption revocation notice all goes through 193.
Okay, so there's no case out there from the Department of Revenue's perspective that is governed solely by the requirements of 151. Is 151 in that sense vestigial, as the Rogers' lawyer said, or does it serve some other statutory purpose from DOR's perspective?
I'm not clear on what your question is.
Well, if it doesn't apply to anything, you say it can be read harmoniously with 193. What is that harmonious reading of those two statutes?
So, okay, the department believes the form and the notice goes through 193.
Right. What work does 151 do?
151 can be read harmoniously and should be read harmoniously with 193.
What is that harmonious reading? What's the purpose of 151?
By meeting the requirements of 193, the notice requirements of 5B, the requirements of 151 have been satisfied. If the opposite doesn't work, though. If you only satisfy 151 by just sending out some sort of a letter. First of all, if you narrowly interpret 151, there's really no deadlines. There's no deadlines for the notice. So you could end up being into a Genesis Ministries version 1 where there's really no deadline and the property appraiser in the fall sends out a notice but doesn't contain very much information. And that's what happened, my understanding of what happened with Genesis Ministries 1. But no, the department considers 193 to control. The instruction to the property appraisers is to let the property owners have reasonable due process notice, not investigative notice as were the terms used by the first DCA in the decision here, but reasonable notice, so that someone on a reasonable person could look at the form and say, yeah, it looks like the property appraiser has information that you're renting out your homestead.
Isn't your form, though, basically designed to not comply with this? The first DCA read this sentence as being a separate requirement. The notice must also include the specific facts the property appraiser used to determine that the applicant failed to meet the statutory requirements. There's nowhere on this form, there's not even a blank space for that.
There is. Where the property appraiser here just listed the title to the statute and the statute number, there's enough space there that you could provide, at least here. It doesn't say how much, and that's part of my presentation in the brief. How many facts is enough? But that space is open. The property appraiser inserted.
But it says meet other statutory requirements, which seems to go with it has to state in clear and unambiguous language the specific requirements of state statutes which the property appraiser relied on. It seems like that's that. And then the first DCA treated this other thing as a separate requirement. And it seems like this form is designed to meet the first part of B, but not the second part.
See, I read the words meet other statutory requirements to meet other statutory requirements as in 196, 193, 5B.
Okay.
So that I understand, but when I read that, that's how
Can you address
that's a blank space there.
Could you address the issue of this? If we're going to read 196, 193 as a whole, and it has the 3 A, B, and C, and then 4 says the property appraiser shall find that the person or organization meets the requirements set forth in paragraphs 3A and B. So it's both. Does that make any sense in the context of homesteads? I mean, this thing about whether you're using it predominantly or exclusively in the classification thing in A?
Well, I'm not directly answering you. If you start at 1A,
well, let's start where I asked
but
you.
1A says all property exempted from the annual. You had asked a bunch of questions to both counsel.
Can you just answer the mic? I mean, I'm not trying to be rude.
Does 3A, B, and C fit? Yes. I think, especially, I recently reviewed the Rebholz case, which was a homestead case predominantly used as homestead, but then was rented out for a boarding house. And that case was decided by this court.
Right. That was about whether, that wasn't really predominant versus exclusive. That was what percentage, is there a portion of the, he had like, a house with like 7 units in it or something, and it's like which portion. So those, the thing about predominant and exclusive, those are terms of art that are, you're the expert, I don't need to tell you, they're defined in the statute. They apply not in the homestead context, they're in these other contexts. So it doesn't, I just want to give you another chance to explain how the 3 and sub 3 and sub 4, how they make sense in the homestead context.
I believe that 3A applies to the homestead context. 3B, depending if a narrow reading of predominantly and exclusively is a term of art, or exemptions that aren't homesteads, and I agree with you that that one would not apply, and the extent to which the property uses for exempt purposes would apply.
Right, and then you go to 4 and it says you have to decide whether they met 3A and B.
Well, 3A, it says 3A and B. So 3A would apply.
And B, though, doesn't. You said it wouldn't.
Using the narrow interpretation of predominantly or exclusively.
Yeah, I mean, so that seems like that's his whole argument, really, is that if you just go back to the very beginning of this thing, it was for these other classifications. We've had these accretions that I think have sort of muddied the waters, but structurally, 151 is for homesteads, this is for the other stuff. I mean, that's really the bottom line.
151 does not have deadlines.
So when you say it doesn't have a deadline, it does have, as soon as practical after March 1st, and then there's immediately, right? If the property appraiser finds the applicant is not entitled to the law exemption, he or she shall immediately make out a notice. The notice has to state the reasons. It tells you where to appeal, what happened if appeal is denied. So what gaps are there in 151 that 193 fills in?
All right, so the property appraiser shall make a decision between March 1st and July 1st. It doesn't say when they're supposed to send the notice.
Well, it says immediately, right? He or she shall immediately make out a notice of such disapproval. If after due consideration, the property appraiser finds that the applicant is not entitled under the law to the exemption asked for, he or she shall immediately make out a notice of such disapproval, giving his or her reasons, therefore, a copy of which notice must be served either by personal delivery or, I mean, why isn't that a sufficient deadline?
If you go back to, depending on how you want to read the periods and whatnot.
Right.
Yes.
So I guess, I mean, do you see any other gaps in 151? I understand your argument on deadlines, but do you see any other gaps in 151 that 193 fills in?
Giving his or her reasons.
So,
There's no
so 151,
specificity.
yeah, just the reasons, the level of specificity that reasons would include. It's kind of the
also
only work
doesn't
151 is, or 193 is doing.
It also doesn't have the Value Adjustment Board notice.
It does, right? The Value Adjustment Board.
Well, it talks.
Yeah, the applicant may appeal to the Value Adjustment Board the decision of the property appraiser. Then if, then the next step would be circuit court. It seems like this, in other words, if you're looking at, and I'm not talking about, history or legislative intent, but if you're looking at these two structurally, it seems like 151 covers everything that needs to be covered from the homestead. Absent the specificity, the level of specificity.
193 says that you have to give notice of the appeal rights of the Value Adjustment Board.
Right, okay, so that would be another
151 just provides for the procedure. So there's procedure in 151 that's not in 193. The notice specificity is heightened in 193. And the department's role with the statewide property taxes is for uniformity. And uniformity for many points, but for efficiency for the property appraiser, efficiency for the Department of Revenue, and due process notice to taxpayers. It's a balancing of all of it, and the department has one form for that.
Does the department have the statutory authority to promulgate this form?
Yes.
Yeah.
What is it?
Yeah.
Don't know.
I mean, is it in this specific statute, or is there some general statute somewhere? Because I couldn't find it in the provisions we're talking about. I see a lot
there
of
is rulemaking. There are form rulemaking statutes, and there's a procedure, and they go through that. In fact, I think the form. I tried to determine when the form was originally used, but I wasn't able to trace that back. But they do. It goes through an implementing process every year, or every time it's changed.
So we've been asking you a lot of questions, but could you just take a couple of minutes to succinctly explain to us your position that even if 193 applies, that this notice complied with the requirements of 193?
On the basis of reasonable due process notice. Now, admittedly, the Part 3, the verification must be, so there's 3 requirements. The notice must be clear and unambiguous language, the specific requirements of state statutes with the property appraiser relied upon. That completed form by the Gregor's office complied. Number 2, the notice must be drafted in such a way that a reasonable person can understand specific attributes of the applicant or the applicant's use of the property, which form the basis for the denial. The notice complied with that also. It's a third requirement that raised difficulty with the first DCA. The notice must include specific facts that the property appraiser used to determine that the applicant failed to meet the statutory requirements. And then the fourth requirement is the notifications must specify the right to appeal before the Value Adjustment Board, which is not in 151. So it's 3 that creates the issue. From the department's perspective is they want taxpayers to have due process notice. And even if technically, depending upon how you want to hear, it's clear that all the property appraiser did was use a title to a statute. They used the number and the title to the statute. So there's no specific facts beyond that. But the question becomes, how much is expected of the property appraiser when the taxpayer themselves or a reasonable person in the shoes of the taxpayer would understand that sufficient notice was given, and that it's to provide, as stated in Gulf Marine, it's to give due process notice so that the homeowner can take the next step necessary to protect their interests, that they have an idea of, okay, what do I have to do next? It's a simple form. The department is attempting to make things administratively streamlined for everyone and meet tight deadlines because of the property tax scheme and the tight deadlines in the scheme. So I think I've answered. Did I answer your question? Did I? Okay.
I don't know how persuasively, but I mean, you answered the question.
Well,
and I'm not saying that to be rude. I mean, it's a tough. It's interesting because in this case, you can imagine some titles of statutes that wouldn't, let's just say it said, improper use of property or something. Here, the title itself tells you that you're renting it and that constitutes abandonment. So that's kind of, the facts are sort of baked into the thing. I mean, it doesn't say you rented it to, Jim Smith for these dates or whatever, but I don't see why that doesn't seem like it would be reasonable to expect a huge level of detail here, so.
The first DCA used the term investigative facts. I think that's adding words to the statute and requirements on the property appraiser. And the other thing to bear in mind is the folks that work in the property appraiser's office, they're not legal scholars, they're not academians, they're filling a role and a function. They're technicians. And there was no harm here. I guess I'll sit down.
Okay, thank you.
Unless there's more questions. I mean, I can go to more points, but the memos from the court was clear that if we don't need to use all of our time, we can sit down. Does anyone have more questions? I mean, the department has been very consistent in its training and in use of this form, and I respect the time, and thank you very much.
Thank you.
Very quickly, Your Honor, the specifics, facts, if they had facts, they could say you rented your main house in 2012 and 2013. There's something, if there were facts, they could reveal them. They didn't have any facts, so I think the legislature's genius is to, if we make them reveal them, that would make them have the facts, which I think has been illuminated here. The 193 in several places incorporates the language here, as my learned counsel here said. The standard is used. All the other counties are using the standard. If when you look at the actual form there, you see they comply with the July 1st deadline, which is only in 193. They provide the VAB appeal rights information, which is not required under 151, and on the form at the bottom you have a right to appeal to the VAB under 193, .193.5. So they acknowledge on the form we're complying with 193 here. We're just only going to do it part way. The legislature requires explicit, simple, but explicit information which was not provided here. The consequence is that the notice is invalid.
Okay. You want to take 5 seconds, 10 seconds to close?
I'll let that be my closure.
Okay.
It's invalid. Thank you.
Thank you very much.
I want to follow up on some of the questions. The use of the terms exclusive or predominantly in 196, 193, there are specific statutory definitions for those terms, and they're all in the context of exempt organizations. That's in 196.012. The rulemaking's in 196.027. The department's argument that now all denials must comply with 196, 193 would require this court to ignore that the very next year the legislature passed the portability exemption and denial language that incorporated the homestead exemption language.
Is the Department of Revenue wrong that it's an empty set? There are no cases processed through 151. They're all processed through 196, 193. Is that wrong as a factual statement?
The only cases that have discussed the denial language of 196, 193 have occurred since the statute was amended in 2007. There was nothing from 1971 to 2006 as to the interplay of those statutes. I would respectfully submit that if the legislature was intending to change the denial requirements for the homestead, they would have put that in 196, 193.5.
Yeah, but that's not an answer to my question. My question is, as a matter of fact, is the Department of Revenue right that there are no cases of homestead exemption denials or renewals treated or considered independently under 151? All of them are operationally processed under 196, 193. Is that correct as a matter of fact?
Your Honor, I don't think you see that in our homestead exemption denial cases. I don't see reference to either one of those provisions. It's simply they didn't receive their homestead. Let's talk about whether they're entitled to it on the merits. Is the case law that we have.
Is it just in practice though? Because I think it's an interesting question, but I just want to make sure I understand the question and the answer. I mean, these appraisers, they're all using the same form, right?
Yes, sir.
And the department treats the form as covering homesteads and everything else.
Yes, sir.
And so to the extent that they're using the form, then they may be consciously doing 151 or 193 or something else, but they're basically, whatever they're doing is just they're using the form, and then we have to kind of sort of infer sort of what's going on in terms of the underlying legal thing that's going on.
I think that's fair. The form also applies to denial of agricultural classification. If I could just talk for I know I ran out of my time on the remedy issue. There were an original complaint and 3 amendments to it. At no time did this taxpayer say that they were using the property as their homestead during the tax year in question. They never challenged the denial of the exemption on the merits. They always challenged it on the failure to comply with the denial language. The Taxpayer Bill of Rights that's referred to, that says there's a right to know and a right to due process. Both of those provisions cite 196-151 and 196-193 sub 5. Right to know, this taxpayer certainly knew why he was denied. Right to due process, this taxpayer filed a Value Adjustment Board petition but then withdrew it. He's not been denied of any rights whatsoever. So we would ask that this court quash the First District Court of Appeals decision, hold that 196-151 is the controlling statute, but even if it did not, that the remedy would not be to grant the exemption, but to allow the procedural due process that's supposedly been denied. Thank you very much.
Okay, thank you very much. We're adjourned.
All rise. This honorable court is now adjourned.